Now, the intermediate scrutiny test is sort of like a not as hard a level to pass. If there's a law that treats people differently, usually it's applied to situations where it treats people differently on the basis of gender, sometimes sexual orientation. They'll go ahead and they'll use the intermediate scrutiny test. The intermediate scrutiny test. To go ahead and pass this test, the government has to prove that there's an important reason for treating people differently. That's all. Not the other two things that they have to prove under strict scrutiny. When it's a law that treats people differently based on gender, they approach it differently. So the government has to demonstrate an important reason for treating people differently. Or, what's the word? Phrase? Compelling interest. I want you to get used to saying that. There has to be a compelling interest. If you're going to treat men and women differently, you've got to go ahead and the government has to go ahead and demonstrate that there's an important reason for doing that. When I was growing up, women could not be police officers. Right? They just were not allowed to be police officers. And the courts had said that's okay. That there was a compelling reason for the government to go ahead and limit women from being members of the police force. The idea was that women couldn't handle the job. It was physically too demanding. And so they permitted that. Those kinds of laws passed the intermediate scrutiny test. But here's a case where it didn't pass. A case called Craig versus Boren. This is 1976. And there was a law, I forgot what state it was, that permitted the sale of non-alcoholic beer to women under 21. So you could be 18 to 21 and you could buy beer if you were female, but not men. Men had to wait until they were 21. Now the rationale they said for that was because, well, they didn't say it like this, but men are stupid, right? They were trying to sort of limit drunk driving and stuff like that. And so they said, we're going to treat men and women differently. And what the court said is, that is not a compelling enough reason. You can't just deny a whole group of people, exclude one group of people from buying this product just on the basis of gender, even if your goal is a good goal. It has to be compelling. It has to be a very important reason. And they said this is not sufficient. Okay, so that's a kind of law that didn't pass the test. You couldn't treat men and women differently in a case like that. Now I realize that among the civil rights issues of the day, whether or not you can drink alcoholic beer, non-alcoholic beer is not a big one. But I think it's an interesting case of something not passing the test. Then the last one is called the reasonable basis test. This is the test that they use if the government wants to, has a law that treats people differently on the basis of age or income. And we have a lot of laws that treat people differently on the basis of age and income, right? Driving, for example, voting, for example, are all instances where we go ahead and we treat people differently on the basis of age. And income, people who make more money pay higher taxes than people who make less money. Until you get, I guess, into the highest brackets and then you go back down again, but that's a different story. To pass this test, the government must prove that a law that treats people differently based on age and income are just related to some governmental interest. It doesn't have to be compelling. It's no longer this standard of you got to show me an important reason. There's got to be a compelling reason. Now the government just has to go ahead and show that there's a legitimate reason for treating people differently. This is the easiest test to pass. So examples of laws that have passed that test, higher taxes on individuals who make more. Legal drinking age being 21. We're treating people differently on the basis of age. And the government has said, and the courts have said, that's okay. They're particularly concerned about, as you can, hopefully you've seen this, they're particularly concerned about laws that treat people differently on the basis of race or ethnicity. Laws that treat people differently on the basis of gender or sexual orientation sort of fall into the next category. That's the intermediate scrutiny test. And then other things like age and income, those wind up being in what they call the reasonable basis test. You just have to have a reasonable basis for treating people differently. These are the three standards that judges use. Go ahead.
So you don't have a compelling interest for reading the basis test?
No. So the standard is lower. You just have to have some legitimate governmental reason for doing it. right? Which is a much easier test to pass than, is there a compelling reason that you have to do it. Now, I also want to go over somewhat quickly some laws, so Supreme Court cases as it pertains to civil rights. We're going to talk about this next week as well, so consider this like an introduction on the next lecture, Plessy versus Ferguson is a very famous case. By the way, all of these links, if you're at all interested in these topics, these links will bring you to summaries of the actual court cases. Plessy, and you should know these cases. Plessy versus Ferguson. This is a very important case. Gentlemen, this is in the 1890s. This is post-Civil War. The guy was 1/8 black, 7/8 white. Didn't look particularly black, but it was he went ahead, and they had white cars and black cars back then, railroad cars. He went in and he got in and he sat down in the white car. Now, just looking at this guy, nobody would have thought that he was black, but it was all set up that he was going to go ahead and get on this train. He had notified somebody as to the fact that he was part black, and the way it worked back then is if you have a drop of black blood, you are black. So he went ahead and got on the train, was told to move to the back, refused to do so, was arrested specifically for the purpose of challenging this law, this separation of the races. And what the courts ruled back then was what we call the doctrine of separate but equal. You can go ahead and you can treat the races differently as long as you treat them separately, and keep them separate as long as you treat them equally. Separate but equal was what the ruling was. Okay, now, just so we're historically clear on this, were the white cars and black cars equal?
No.
The white schools and the black schools? Hospitals? No, none of it was. But what the courts had done is essentially given cover to the southern states to continue to treat blacks differently. But what the court said is it's not a violation of that equal protection clause. Go ahead, Nick.
Wait, so what was he testing? Was he testing the separate but equal doctrine? Or
No, he was testing the law that required blacks to sit in a different car than whites. Right? And they said, and essentially they ruled, yes, that law is constitutional. They can be separate as long as they're equal, and that doesn't violate the equal protection clause in the 14th Amendment.
So that would come under the strict scrutiny, right?
Yeah, that would have come under the strict scrutiny test, although I don't know that they were applying that in 1896.
Oh, okay.
In 1954, there was another case, Brown versus the Board of Education. Now, Brown versus the Board of Education was actually a number of cases all folded into one. There were a series of cases that were involved. But in this case, what the courts did is they ruled that the decision in Plessy versus Ferguson was wrong. It was just wrong. And they ruled that if you have separate cars, separate schools, separate hospitals, if they're separate, they're inherently unequal. They're inherently unequal. There's no way to be equal and have them separate. And so they struck down all these segregation laws and said that the states had to go ahead and limit segregation. The phrase they used was with all deliberate speed, right? With all deliberate speed, they needed to start going ahead and taking it apart. Remember we talked about Brown versus Board of Education when we talked about the Supreme Court, and I talked about how does the Supreme Court enforce its rulings? Pardon? They can't. They don't have any means. And so after Brown versus Board of Education, Little Rock High School was supposed to integrate. And the governor of Arkansas stood at the steps of the school and said, "Over my dead body." And it wasn't until the president sent the National Guard in and forced it to happen, essentially, that it was integrated. So, go ahead, Ben.
The governor at the time was Strom Thurmond, wasn't he?
Was he governor?
I know he was governor at some point. It had something to do with, it was either in Mississippi or Arkansas, since the right state.
Yeah, he's from South Carolina.
Yeah.
I heard the governor
I think it was.
sent in the National Guard and the president sent in the Army.
I think the president nationalized the National Guard, and you couldn't send the army in. The army can't come into.
I was just taught that a couple weeks ago.
I think the National Guard stopped this, I think they're called the Little Rock Nine, from coming to this school. And then the president turned around and had the National Guard escort them to the school.
He nationalized it. In other words, the National Guard belongs to the states, but the president can, by his authority, essentially nationalize it, and then they are under his command.
So the Army never played a part in it?
No, you can't. The U.S. you can't send the Army onto domestic soil.
Oh, okay. Oh, okay.
Yeah, that's frowned upon. The framers would, I think they would actually roll over in their grave